There is a body inside the Department of Justice called the Office of Legal Counsel. It appears in no law you have ever read, no one voted for it, and it has been issuing binding legal opinions since 1934 that the government has no obligation to show you. Some of those opinions are still classified. They govern what your government is allowed to do to you. Most people know there are 3 branches of government. What they don't know is that there is a 4th layer, not a branch, not a court, not an agency with a public mandate, but an office inside the executive branch that functions as the president's private law firm, the Office of Legal Counsel, the OLC, staffed by roughly 24 attorneys. They answer legal questions for the president, the attorney general, and every federal agency that needs to know whether an action is lawful. Their answer is not a suggestion, it is binding. Every department in the executive branch must treat an OLC opinion as settled law. Not a judge, not Congress, a small office you were never introduced to. The OLC was not created by an act of Congress. There is no statute that establishes its authority, defines its scope, or limits what it can decide. It grew out of internal executive reorganizations, bureaucratic reshufflings through the 1930s and 1940s that no voter approved and no legislature debated. The legal basis for its binding authority rests entirely on executive tradition and one internal Department of Justice regulation, 28 CFR Section 0.25, a rule the executive branch wrote for itself. Congress did not write it. Congress did not vote on it. The executive branch decided on its own that one of its own offices would have final legal say over everything the executive branch does. And then it codified that decision in a regulation most Americans have never heard of. An institution with the power of law built entirely on the authority of its own say-so. Who controls the OLC? The Assistant Attorney General for the Office of Legal Counsel, a political appointee nominated by the President, confirmed by the Senate. That is the only democratic check in the entire chain. Once confirmed, the office operates. It issues opinions. Those opinions govern federal agencies. The public doesn't vote on them. Congress doesn't ratify them. Courts rarely see them. And here's what you need to carry with you. Remember, no one voted for this. The OLC can issue an opinion, classify it, and the legal rule it creates becomes binding on your government without you ever knowing a rule was created at all. In 2002, the OLC issued a memorandum. You may know it as the torture memo, written by Deputy Assistant Attorney General John Yoo. It concluded that certain interrogation techniques any plain reader would call torture, did not violate federal law. That opinion governed what CIA and military interrogators did to human beings in classified facilities around the world. It was not a court ruling. It was not a statute. It was an OLC opinion, classified, binding on the entire executive branch, and invisible to the public until it leaked in 2004. The actions it authorized were already happening before anyone outside the government knew the legal permission existed. That is the architecture. A legal opinion is issued. Agencies act on it. And if the opinion is classified, the public has no way of knowing that a rule existed, that the rule authorized specific conduct, or that the conduct was underway. The rule, the action, and the authorization are all inside the same building, all answerable to the same branch, visible to no one outside it. Your government has a formal mechanism for creating secret law, not secret regulations. Secret law, binding, enforceable, invisible by design. And here is the part that should actually worry you. It is completely legal. Congress could pass a statute requiring OLC opinions to be publicly disclosed. It has not done so. Courts can compel disclosure through FOIA litigation, but only when litigants can prove a specific opinion exists to ask for. The ACLU has spent years suing for opinions it could demonstrate were real. It won some. Many others remain sealed. What no one can do, not Congress, not the courts, not a future administration, is undo the structural logic. As long as the executive branch needs internal legal guidance, there will be an OLC. As long as national security justifications exist, some opinions will be classified. The mechanism is self-perpetuating. It does not require your consent to continue. It never did. What this tells you about every other institution is this. The law you can read, statutes, court decisions, the Constitution itself, is not the whole law. There is a layer of executive legal interpretation, some of it public, some of it permanently sealed, running beneath every rule you know about. Every federal agency, every presidential action, every counterterrorism program operates under a legal theory. Some of those theories are in opinions you can find. Some are in opinions no one outside the executive branch has ever been permitted to see. The body that produces them is small, unelected, and shielded by design from every accountability mechanism that is supposed to define democratic governance. This is not a conspiracy. It is a design feature, and it has been operating continuously since before most of your grandparents were born. Here is the question no one inside that building will answer publicly. How many OLC opinions are currently classified? The government has never published a number, not an estimate, not a range. No one outside the executive branch knows how much law exists that they have never been permitted to read.